Hey, let's spend a couple of minutes talking about the three things you have to remember about every self-defense scenario. When we take a look at RCW 9A.16.020, a statute which looks just like this, and we try to break it down, if we could take this statute and all the case law that deals with self-defense scenarios, what we would see is that all lawful self-defense scenarios have to fall into three categories. And so if I could take all of the self-defense law and put it in a nutshell and sum it up in three words for you, this is what it is. The force we use has to first be necessary. That is that there is no other reasonable alternative other than the use of force, excluding retreat, because retreat is not part of that equation. So it has to be necessary. Number two, it has to be reasonable. The use of force has to be reasonable, both from a subjective standard, that is when the jury puts themselves in your shoes, and an objective standard, which means we as a society can recognize why force needed to be used in that situation. And the third, and perhaps most important, because this is the one that people end up in the most trouble for, it has to be proportional. That is, the force that we use has to be proportional to the force we are defending ourselves against. So, in a nutshell, the three things that we have to remember about every self-defense scenario is the force we use has to be necessary, it has to be reasonable, and it has to be proportional. And if it falls into all three of those categories, yes, you in all likelihood have a lawful self-defense claim. And if it fails in any one of those three categories, well, you may be criminally liable at that point. Listen for a more detailed discussion about the self-defense laws here in the state of Washington. Check out some of these videos right here on our channel. My name is William Kirk. I am the president of Washington Gun Law, and you have been watching Bullet Points.